All right. All right, just let me recap. My apologies for that. So what this act deals with is this expanded definition of who is classified as a developer to include the principal contractor for the work. Secondly, it deals with this issue about it only covers residential apartment building work, and it covers the products that have been constructed as part of that work itself. The Act catches that any work for which a complying development certificate or construction certificate has been issued up to 10 years before the 1st of September this year. So when you think about it, this will capture building work and products which may be found to be defective as from 1 September 2010. We're going to look at these last two issues tonight, which deal with what notice is required to be given by developers to the Department of Customer Service. The first thing is under Section 7, that the developers must notify the Secretary of the intended or their expected completion date of the work at least 6 months, but not more than 12 months before applying for an occupation certificate for their particular work, or applying for the registration of a strata plan. The notice that is required to be given requires that the developer will identify the date on which he expects to make the application for the occupation certificate. Now, the legislation makes provision for a 6-month transitional period from the 1st of September 2020 up until the 1st of March next year. During that time, these provisions under Section 7 have been shortened. In other words, during the transition period, if the developer expects at the commencement of their work to make an application for the occupation certificate within less than 6 months, the developer must notify the Secretary of the Department of Customer Service of the proposed application, and it has to have happened within 14 days after the 1st of September. In other words, by 15 September. Now, that period has already passed. What this legislation seeks to do is make provision for this notification. I expect that if you are in this position where you expect to commence or complete your work during this transition period, and you haven't yet notified the Department of Customer Service in relation to your expected completion, that you should now do so as a matter of urgency. The reason for that is, firstly, there are penalty notices for individuals for a fine of up to $3,000, and for companies a fine of up to $11,000. It's important, even if you are outside that period, in other words, if you haven't yet notified the department, that you do so, and do so as quickly as you can. That will enable you to be able to provide that you have complied with the legislation, and I'm certain that because of this transitional period, there will be a number of developers / principal contractors that may be caught out by this provision requiring them to make or give notice of their expected completion of the work. The next provision relates to any changes that the developer they expect there to be a change in the expected completion date of the work. They should again notify the Department of Customer Service. Any changes to the work or expected change in the expected completion date should again be notified in writing to the department. As I said before, during this transitional period, if there is a expected completion date during this period, in other words, up to the 1st of March next year, then as soon as you become aware of any expected change to that completion date, provide notice in writing to the department. There are hefty fines for failing to do so for individuals carrying out building work or developers, or corporations that fail to comply with the legislation. They will or may be liable to make a payment of a fine of up to $5,500. What I think this legislation is trying to do is increase the requirement for notice to be given by developers relating to the anticipated completion of building work. They are to give that notice as soon as possible of the expected or intended completion date, and do so in writing to the department. Now, Section 9 of the Act is important because this sets out what we call a prohibition orders, which may be issued by the Department of Customer Service as part of their increasingly monitoring the completion of building work and whether it complies with building contracts and or design, and or whether the building products that are installed comply with the design and or the Australian codes and standards. The significance of failing to make or provide notice to the Secretary of the Department of Customer Service relating to the expected completion date is that you may face a prohibition order. Secondly, a prohibition order may be issued for the particular development where notice is given less than 6 months before the application was made, or where the developer has failed to notify the Secretary relating to this change in the expected completion date. So remember, we spoke earlier about any expected or anticipated changes in the completion date of building work. Again, if you expect or anticipate or there is some delay in the project, or that should be notified to the department so that the department has an opportunity to have in writing the expected completion date for the project. The other reason why it is important to comply with these notice provisions in the Act is that it is clear that the department will be sending out inspectors to review the construction of the work, to ensure that the building work and building product and design meets the compliance, say, with the development consent, and or meets the various codes and standards. Serious defect, again, as we discussed before, covers work for which you may have a failure to comply with the building work, failing to comply with the relevant codes and standards, and the same which may apply for defective building product. The other reason that the department may issue what we call a prohibition order, which prevents the issue of an occupation certificate, or which may prevent the registration of a strata plan, is where a building bond has not been given by the developer at the time of the commencement or after the contract has been signed. Now, this notice or the provision of a building bond is not new. It was introduced as part of the amendments to the Strata Schemes Management Act 2015, and there were several years delays in actually implementing it. But if the developer has not deposited with the Department of Customer Service a building bond, which is equivalent to 2% of the contract price, then this may form another ground on which the Department of Customer Service may either issue a prohibition order to prevent the issue of an occupation certificate or to prevent the registration of a strata plan. So the important takeaway point for these notice provisions is give notice relating to expected completion date, ensure that that notice is given to the Department of Customer Service in writing. Ensure also that any changes to the expected completion date are also given in writing to the department, and also ensure that the developer has given or deposited with the department the building bond which is an important provision. Now, this slide sets out the importance of the amendments to the legislation in terms of how they may affect the completion of the work and the necessary settlement and sale of apartments which have been completed. The Act, as I said, when you look at the slide, I've introduced a timeline with relevant dates from completion through to the registration of the strata plan. I've also set out the effect of the legislation in terms of its interference with the building work completion, and at worst, where the department is not satisfied, that relevant notice about the completion has been given and may decide to issue a prohibition order preventing the issue of an occupation certificate. Interim occupation certificates are given, for example, we may have a staged completion with some work completed on one part of the project and further work to be completed at a later time. Final occupation certificate is really the certificate which, as we know, authorises the occupation of the building, authorises compliance with the development consent, and where the certifier issues or that the certifies that the building work complies with those requirements. The legislation seeks to interrupt that, to say that any notice relating to the completion work has to be given to the department, and clearly there is provision in this legislation for departmental inspectors to attend site to ensure that they will inspect the building, to ensure that necessary compliance with codes and standards has applied or does comply. I've mentioned the defects liability period. If we're looking, for example, at HIA contract, again, there's made provision for that. The defects liability period is a period during which everything is completed with the building work, with the exception of minor defects and or minor work and or minor defects in the building itself, except for which relates to work which where the building is reasonably fit for occupation. Nevertheless, the defects liability period is a period during which, if appropriate, the building owner will give notice to the contractor to rectify certain defects. The end process beyond the defects liability period, and once that finishes, is that the developer is then able to register the strata plan, which means that they are able to subdivide the lots, and then that permits the sale of those lots, and the cash flow happens for the developer. The effect of this legislation, as we can see on the slide, is this: that if the relevant notice about the completion is not given, and or the deposit bond is not provided, and or there's found to be relevant defects by departmental inspectors, then the department may issue a prohibition notice which prevents the issue of an occupation certificate and or prevents the registration of the strata plan for those apartments. So, serious consequences for failing to issue the notice, failing to comply with these requirements. The department may inspect the work, may decide to review, and if appropriate, if it finds that there are serious defects, issue an order for remedial work. And during that time, it may prohibit the issue of an occupation certificate or the registration of a strata plan. Can also recover various costs and expenses involved in that. So, what can contractors and or developers do? There is provision in section 49 of the Act for the developer to lodge an appeal against any orders which may be issued by the department. That appeal is determined through the Land and Environment Court. I'd also suggest that if you are involved as a builder and or developer in this process, to check your contract. If your expected or anticipated completion date is likely to occur up till the 1st of March 2021, that you check your contract and make provision that you are able to ensure that the developer complies with this legislation. Similarly, notice provisions and processes and systems I recommend be set up to ensure that we have an adequate process for identifying defects. We have an adequate notice to ensure that the intended expected completion date is given in writing to the Department of Customer Service. Equally, check whether the deposit bond of 2% equivalent to the contract price has also been lodged with the department. These, in summary, are the key effects of the new regime regarding the issue of occupation certificates. I think it's important to say that this legislation is important. It allows the departmental officers to inspect building work for as far back as 10 years from 1st of September 2020. So as well as that, they may inspect work for projects which have been completed up to that time. It also prevents the department or prevents the developer from receiving an occupation certificate, and or in appropriate cases, it may prevent the registration of a strata plan. That, of course, interferes with the cash flow with the builder and developer, and also may have serious consequences for the completion of the work and the sale of the units which have been constructed as part of that development. That ends my presentation. If anyone has any questions, I'd be very happy to take them, and thank you for your time tonight.
Thanks, Anthony. We do have a couple of questions from Bruce Morrow. I will ask him to come off mute and ask away. Are you there, Bruce?
Yes, good evening.
Good evening. Hi, Bruce.
Good evening. With all these changes, where does this leave the owner of a unit who undertakes partial renovation of their unit in terms of their prospect to actually stay resident in that unit during those constructions? Because this whole links into this whole occupation certificate.
Yes, it does. Yeah.
Yeah.
So,
and does that actually make them a developer in the context of what's, they're hiring the builder? So does that make them a developer?
Well, yes, a homeowner may be regarded as a developer where they arrange for or contract for the provision of building work to be carried out by another party. So yes, to answer your question, they may be regarded as the developer or the owner of the land. So they would be caught by these notice provisions. The legislation also makes provision, Bruce, for work on part of a building. So it includes alterations and additions, not only to a building, not just new building works, in other words, new developments, all right? So for example, if you were a homeowner carrying out amendments or additions to your strata complex or your building, then this legislation would apply to you in terms of you being regarded as a owner builder or a developer. You'd need to provide notice to the department about your expected completion date for the building work. And so you'd be caught by this legislation as well. And the other thing about this legislation, as I said earlier, it captures all work for compliant development certificates and or occupation certificates for work up to 10 years from 2020 back, in other words, between 2010 and 2020. So the effect of the legislation is pretty far-reaching.
Yes, I would see that there are many people out there, unit owners, who would just be totally unaware of the liability being covered.
I think that's right too. Yes, yeah. And I think that's one of the reasons, Bruce, that they've introduced this requirement for what we call a transitional period. With this legislation, not everybody's aware of its operation. Certainly, the legislation requires that during this transitional period, in other words, up to the 1st of March next year, any expected completion of building work will need to be notified in writing to the department. And so I expect you probably have a number of people that would be caught out by this. But I think the effect of this legislation is try to increase the notice given by developers to the department about anticipated completion, to allow the department, if it desires, to go out and inspect the work before it issues a occupation certificate. Equally, for projects for which an occupation certificate has been issued, or for example, where you have strata plans that have already been registered from 2010 to date, the department may also be allowed to issue an order revoking the occupation certificate or the registration of the strata plan. Pretty serious consequences, you'd say. They're more likely, I think, if they find there's evidence of defective or incomplete building work or a defective product which has been constructed as part of that work, to issue an order for remedial work to be carried out.
Yes, it seems to also, because there isn't a limit to the scale of the actual building works in there that I can see. That even minor renovations could come and be affected. And a question is, an occupation certificate is an occupation certificate. Does an owner have to move out of their residence for these minor scale works to be undertaken?
It's a good question. I think probably it would depend on the nature or scope of the building work or remedial work that's required. If you've got major work that needs to be done, for which the builder requires complete access, in that instance, it may be required that the homeowner may need to move out. If you've got work that may be done to a discrete part of the build, then the owner might be able to reside there during the meantime. I expect that's probably your worst case scenario, but that's not unheard of. If you've got work which needs remedial touches to it, the department can order this remedial work, and then I expect that any expenses that may be incurred by the homeowner during that time may be recoverable. I think earlier tonight there was another piece of legislation, the Design Building Practitioners Act, which may have been spoken of, and the duty of care. I think one of the earlier speakers spoke about that. But the point of that legislation is that defective building work and or defective products may result in an order for remedial work, and the homeowner may sue or make a claim against the builder and or the developer for that work to be carried out, and that includes alternate accommodation if required. So to answer your question, I think depending on the scope required, alternate accommodation, if that's required in terms of access for the builder to carry out his works to fix the defects or defective product, alternate accommodation may be claimed by the homeowner that's affected.
Yes, in a defects context, but
so
the front end.
Yeah, so sorry, when you look at this legislation, but
if I
no, it's fine.
You're right.
Yeah, sorry. Yeah.
If you go back to Brookfield was basically a situation with failure of the waterproofing, and also the installation of non-galvanized lintel beams were the two core elements that created in the in the apartment building section of that tower, not in the residential. Well, affected the residential section, but that was covered, and the retail section that was covered by a different perspective. But to cover the point that I mentioned before, there was a very complex arrangement of large organisations. You know, the apartments were going to be managed by a special apartment managing organisation, where in all the purchases of these units that were going to be managed by that organisation, they handed over all their management rights to them. And to some extent, I find this legislation very nice if you keep everything simple, but could be an absolute screaming nightmare once you start to look at these development type processes where you get two major organisations, Eddie Kornhauser on one part and Brookfield's on the other, get together, put up a development company, you know, build the building, and then sell it on, having then established the strata. You know, there was a whole issue of vulnerability in there, and this sort of, you know, standard development process, it doesn't seem to be reflected. It's sort of like to me, it seems to be like a house building project. Yeah, and in its simplicity.
Yeah, just on Brookfield. Brookfield was, as you know, a case which sort of really assisted builders. In other words, it said that the builder still owed a duty of care, a statutory duty of care under the statutory warranties under the Home Building Act, and that always applies if you've got residential building work carried out. Brookfield said that the builder doesn't owe any duty of care beyond that. So in other words, there was no common law duty of care. Yeah. On the other hand, this legislation and the, more importantly, the defects of the building design legislation that we just spoke about adds this common law duty of care. So what it says is that the builder owes a duty of care for defective work as well as defective building products and or design, if it's responsible for the design, for example, with a D&C contract. So really, what the Design Building Practitioners Act just is an add-on in terms of the duty of care. In other words, the requirement for the builder and or the designer to have to take care in the provision of their work and design, and they owe that duty to building owners. And so that is something where the that Brookfield has been surpassed in terms of the duty of care that the homeowners can rely on, compared to the duty of care that they could claim against the builder as per the Brookfield decision. Okay. Part of the reason with the Brookfield decision why the owners wanted to sue the builder at common law, in other words, in tort, was because they were out of time to claim for defective building work under the Home Building Act, which is 6 years. So what they...
Yeah, the situation there, because I'm familiar with the case as well, the situation, the ones who were suing were the ones who had purchased these units that were going to be managed by a professional apartment company. So they were treated as a commercial business, not as a residential home, and that had a major part in that in terms of going for economic loss.
Yeah, exactly, and just on that point, Bruce, they were these people who were making the claim were regarded by the court as sophisticated investors. So they were like your equivalent to ordinary mums and dads.
Yes.
And the court said, okay, you're different to the ordinary people that buy off the plan and after the building is complete. And then they find that there's a problem with the work or the design. Yeah. These people, as you pointed out, were in a different category. In other words, they were regarded as more sophisticated. And therefore, the court said, well, because you're more sophisticated, you've got a greater opportunity to go and get advice, to check before you buy. And so that was why they put them in that different category. So I hope that answers your questions. But I think what this legislation and that Design Building Practitioners Act is to say, look, the department wants to know about the intended completion date of a building as soon as possible. And it then intends to go out and inspect these new work that have been or likely to be completed, as well as going to inspect works that have been completed within the last 10 years. It's a pretty tall order when you think about it, given the number of buildings that have been completed since in the last 10 years in New South Wales. That's apartment buildings that are caught by this legislation that we're talking about. To that extent, I think the Department of Customer Service has a staff of about 185, and I think they have dedicated inspectors and certifiers, and I think an architect. They go out in groups of 3, or that's their brief, to go and look at these new developments. So yes, the department does intend to take these new notice provisions very seriously, does intend to go out and inspect works. And so that's the reason I think I've highlighted those issues now about why it's important to give notice about your completion of work, because that can affect whether you were, as a developer and or your builder, receive your occupation certificate because of those requirements.
Okay, thank you for that.
Just a pleasure. Thank you.
If I may.
Luke Harris had a question. Are you there, Luke?
I'll have a sit there.
Yeah, I'm here. You got me?
Yeah, we got you.
Yeah, Luke.
Are there provisions for, say, an example, an individual unit owner within a strata building doing a renovation of a unit that takes 2, 3, 4 months, though the requirement for the notification is minimum 6 months from completion of the works for the OC? So what happens there? Is that a ticking time bomb for?
I think the first thing is if the Act is designed to cover work for apartment building work or parts of it, building element, it also means that if it really seeks to shorten the notice period to be given by the developer or owner or person that's owning the project and or the principal contractor to give notice in writing to the department about when they expect the building work to be completed. So yes, it'll mean that there will be a flurry of paper, or most likely has been already, up until the 15th of September, which is when these new notice provisions closed. So I expect that the department will also happily receive late notices, because that's one of the reasons why it's introduced this transitional period, to try to give people an opportunity to catch up with the legislation,
Yeah.
But you're right. I mean, there'll be more onus placed on notifying the department about what works are going to be done, when they're likely to be completed, and that will mean that the department is very likely to go out and instruct inspectors to inspect the work.
Yeah, well, for those short-term projects, it's almost like you get your CC and you lodge your application for OC at the same time.
Yeah, I would think so, yes. Yeah, and you do that in writing and give your notice of when you expect the work to be finished. And then if there's a delay in that expected completion date, again, give notice to the department. So there's a process which needs to be followed, and that's why it's important for developers and principal contractors to be aware of it and keep giving notice if there's any change to that to the department. So in other words, what you've got is you've got a process which says, all right, we've got expected completion date. We need to give the notice to the department. Check we've lodged the deposit bond. If the developer hasn't already done that, we should do so ASAP. If we've complied with giving notice, then we are on a much better footing to be able to receive an occupation certificate and or a registration of a strata plan, which will mean that we can then sell the unit and then have our project completed, and then monies can flow, and then of course the building can be sold to the purchasers that have bought off the plan.
Yep.